When you are questioned during a pretrial deposition, a pretrial examination before trial, is there a judge present to decide issues between the attorneys? Would you like to know the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. In New York, in a medical malpractice case, in an accident case, even in a wrongful death case, the short answer is no. There is no judge present to resolve any issue that arises between the attorneys. So you might be thinking, wait a second, what happens if the defense attorney asks me a question and now my attorney is objecting and they can't resolve this? What happens then? Well, there are a number of options that can occur. The first is that the attorneys have a discussion, a very brief discussion, about why there's an objection, why they think that this question is inappropriate, and whether or not you, the witness, can answer the question. If that cannot be resolved, one issue in terms of resolving it, or at least putting it aside for the moment, is to mark it for a ruling. And what that means is that to signal to the court stenographer to go ahead and make a little notation in the transcript that later on, if anyone wants to see if there are any issues that came up during the course of this pretrial question and answer session known as a deposition, they have easy reference for the particular page number and the line number where this objection was raised. And now, if the defense attorney, after the deposition is completed, still has a problem, now there is the possibility that they could ask the court, ask the judge, make a formal written request to take action based upon the objection that was raised. And sometimes the defense attorney will go ahead and actually make this formal written request to the court if they think it's important enough. Many times it's not important enough and they will hold off and not take any action, but simply mark it for a ruling. Another alternative that could arise if the discussions between the attorneys become heated and now things become unpleasant, and maybe there's some yelling or screaming or unprofessional behavior. One extreme option at that point is for your attorney to bust your deposition, which means your deposition is finished and the defense attorney has now lost their opportunity to go ahead and continue questioning you. In that instance, your attorney and you are going to get up and walk out of the room, and you are not going to come back. That can create a problem. And now it creates an unknown question mark about what will happen afterwards, whether or not you will have to come back to continue your pretrial deposition. In some cases, you may have to. In other cases, the court may determine, no, this was outrageous behavior, this never should have been asked, this never should have been addressed, and therefore your deposition is completed, and now your attorney will move on to the next deposition. That is the extreme scenario. It is much more likely that the attorneys will have a brief conversation about why there's an objection and whether or not the client or the injured patient can go ahead and answer the question. The defense attorney now has to decide whether or not to ask a different question, rephrase the question, go on to a different topic, or simply continue harping and digging their heels in to try and get a specific answer to their particular question. And that's on a case-by-case basis. There are some instances where a defense attorney simply cannot, for whatever reason, rephrase their question and thinks that they have to ask that exact question in the way it's phrased. Your attorney may think it's a totally inappropriate question, or your attorney may believe that the question is palpably improper, which means that the question is so off the wall, outrageous, that there is absolutely no reason that the defense attorney is asking this question. Maybe it's a scenario where the defense attorney asks you a question about what it is that you and your attorney spoke about before the questioning started. Your attorney objects and says, no, this is a privileged conversation. It's protected by attorney-client privilege, and the defense attorney might keep arguing, although it's unlikely. But just in this hypothetical scenario, it could happen where the defense attorney keeps arguing that this is an appropriate question. Your attorney says, no, it's not. Move along, counselor. Ask your next question. And the defense attorney refuses. All right? So in that instance, if the defense attorney refuses to ask a different question, what happens then? There's no judge there to resolve this issue at the moment. One option that could occur, but doesn't happen very often, is that the defense attorney could threaten to call the court. Or they could actually go ahead and call the court. Now, there are a number of drawbacks associated with an attorney calling the court in the middle of a deposition. So remember, these depositions take place, they typically start in the morning, maybe about 10 o'clock in the morning. And now, if there's an issue that arises, and now the defense attorney wants to call the court to get a ruling on whether or not a question is appropriate, there are a couple of things that happen that you may not realize. Number one, the judge likely will not be available. The judge may be on trial. The judge may be handling other matters in court. The judge may be away. There could be many possible explanations for why the judge will not get on the telephone to go ahead and listen to this minor dispute about whether or not a question is appropriate to answer in this pretrial deposition. On the other hand, a judge may get on and now say, okay, what's the problem? And now in the span of 1 or 2 minutes, the judge is now expected to listen to the issue and to make a snap decision about whether or not the question is appropriate and whether the witness has to go ahead and answer that question. But there's a problem inherent with that. The problem is the judge knows nothing about this particular deposition. And the judge now has to listen to the defense attorney, explain the circumstances surrounding this particular deposition, surrounding the questions that he or she was asking, surrounding the objections that were made and the reasons why they were made. And after presenting this to the judge, now the judge will have to listen to the opposing attorney and their explanations about why this question was inappropriate and why it should not be answered. And then the judge will have to make a snap decision. In many cases, this conversation is not recorded, meaning it's not on the record. So, the judge then renders a snap decision, and whatever decision the judge renders, if this is not being transcribed and recorded, it's no longer appealable. There's nothing on the record, and now the question is, okay, are the attorneys going to abide by this judge's informal telephone ruling? If the answer is yes, and now there's an issue later on, can that be appealed? Most likely the answer is no. What happens, though, if the defense attorney says, listen, I'm calling the court, I want to get a ruling. Let's say I'm the attorney with my client and I think the question is inappropriate. Now, I turn around and say, you go ahead and call the court. I am not participating in that conversation. And you say, wait a second, don't you have to participate in the conversation if the other lawyer is going ahead and calling the court? The answer is no, I do not have to participate in that conversation. Okay, so what's the implication if I do not participate in that conversation with the court? The answer is that conversation will not happen with the court. Now, you might be wondering, wait a second, I'm totally confused. Well, in these types of cases, these medical malpractice cases, these accident cases, and these wrongful death cases, one side is not permitted to speak to the judge alone. That's known as having an ex parte conversation. In that instance, the defense attorney could not call and speak to the judge by themselves and then get a ruling about what should happen during the course of this deposition. That could not happen. So the judge would not get on the telephone unless all parties were present on the call and willing to present and listen to what the judge had to say. If only one side was on the telephone, that is known as an ex parte conversation, and the judge would not be able to have a discussion with just one attorney and then make a ruling without the other side being present. Now, why would that occur? Why might that occur? It might occur because the judge is at a disadvantage. The judge does not know the specific details of what went on during this deposition. The judge does not know exactly what the claims are in this particular case, and the judge is not going to have sufficient time to research it and to learn the details of this particular case. And there might have been other issues leading up to this objection. Now, we're not going to have sufficient time to educate and teach the judge about that particular problem. So the better practice, in my opinion, is, look, you have a problem, I have an objection, I don't think it's inappropriate, mark it for a ruling, and now after the deposition, you are welcome to go ahead and make a motion to the court, and now ask the judge for a ruling. But this way, the judge will have the transcript of everything that went on and be able to read it in order to make an educated decision about whether or not this particular question was appropriate. In that instance, now the judge can rely on the actual testimony, as well as the comments and the other questions that were raised that may have been inappropriate as well. and let the judge come to a ruling based upon the totality of everything that went on leading up to that inappropriate question. In my opinion, it's a much better way to deal with this and get a ruling at that point, if it's an important point, and then the judge can make a ruling about whether or not my client has to return in order to continue asking questions along this particular topic. So why do I share this quick information with you? I share it with you just to open your eyes, to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.